Hello friends, in the series on the income tax cases, today we will discuss an issue which is based on the concept that if in law, if some procedure is given to do a task, then that task should be done only according to that procedure and not by any other mode. The present issue in the present case was that the special audit was recommended by the Commissioner of Income Tax, while according to section 142 subsection 2A, it is only the prerogative of the assessing officer to propose for a special audit by taking the views of the assessee. And secondly, the time limit in which the special audit is to be completed is to be determined by the AO and not by someone else. In the present case, the CIT has given a time frame to complete the special audit, and the extension of the time for the special audit was asked by the special auditor, while the proviso to section 142 subsection 2C says that the extension of time limit to do the special audit can be given only by the assessing officer suo motu or on the request of the assessee. So when there are so much lapses in the procedure, then in that case, what is the fate of the assessment order which is passed by taking the base of the special audit? This issue has been taken up well by Delhi ITIT F bench in the case of Deputy Commissioner of Income Tax versus Patanjali Ayurved Limited, and this case is reported in 121 ITR Tribunal, short notes 14, and the date of the judgment is 27th December 2024. The present case relates to the assessment year 2010-11. At that time, the time limit to complete the assessment was 2 years from the end of the relevant assessment year, so the limitation date was 31st March 2013. The learned assessing officer recommended the special audit under section 142 subsection 2A by writing a notice to the assessee on 13th March 2013. The assessee objected to this special audit. When the objections were received by the assessing officer sent proposal to the CIT for the special audit, and then CIT appeal issued show cause notice to the assessee on 21st March 2013 by show causing the assessee that why the special audit should not be done in the case of the assessee, because there are a lot of complexity in the accounts of the assessee. The assessee objected to this show cause notice by the commissioner, but ultimately the Commissioner of Income Tax approved for the special audit on 28th March 2013, and ultimately the AO ordered for the special audit on 30th March 2013. The assessee filed a writ petition against this order of special audit, which was stayed by the High Court, but ultimately the writ petition was dismissed by the High Court on 6th December 2018. Then the special audit report was given by the special auditor, and on the basis of that a lot of additions were made. When this matter was before the CIT appeal, the assessee was also challenging the whole special audit. It was the submission of the assessee that since the time barring is on 31st March 2013 and the special audit has been ordered on 30th March 2013, so it was the submission of the assessee that the special audit has been recommended in the case of the assessee just to take the benefit of the extended time of completing the assessment. When this matter was heard, the CIT appeal was convinced with the submissions of the assessee, and CIT appeal said that in the present case, from the facts and circumstances of the case, it appears that the special audit has been recommended only to buy the time for completing the assessment. The CIT appeal as well as the tribunal was of the considered view in the present case was that as per the mandate of section 142 subsection 2A, it is only the prerogative of the learned assessing officer to recommend for the special audit, but in the present case, it seems that the Commissioner of Income Tax has jumped into the matter and he has recommended the special audit. Secondly, as per section 142 subsection 2C, the time limit for completing the special audit is again the prerogative of the assessing officer, but in the recommendation of the Commissioner of Income Tax, he has given the time frame to complete the special audit. Thirdly, in the present case, whenever the time limit to increase the for the completion of the special audit is concerned, then only the AO suo motu or on the request of the assessee can extend that the time limit to complete the special audit. But in the present case, the time limit to complete the special audit was given extension on the request of the special auditor. So on these three grounds, the special audit was termed as illegal, and accordingly all the assessment proceedings were quashed by the tribunal. Friends, this case is very important because it throws a sufficient light that the procedures are very important in the Income Tax Act. At the end of this video, once again I am repeating the name of the case. The name of the case is Deputy Commissioner of Income Tax versus Patanjali Ayurved Limited, and this case is reported in 121 ITR Tribunal, short notes 14, and the date of the judgment is 27th December 2024, and the judgment has been given by the ITAT F bench. Thank you, friends.